to, obviously the second and the final block of seminars for this term, before you break for the winter and come back next term. I'll be taking the seminars for the rest of the term. Yes?
Any way you can speak louder?
I can. Yes, as an Australian, projection has usually not been a problem for me. So, especially for those of you in the very back row, if you can't hear me, then just put up your hands. There's a sort of strange humming, and I don't know whether this is because we're in an engineering meeting. What's that?
It's the AC.
Oh, okay. And that we don't want to turn off, as I think we found out last time. That was bad. So, in today's class, we will be looking at a sort of overview of trademark protection, looking at sort of different types of trademark, and sort of the very basic rules relating to both registration and validity. You will notice, in fact, actually, for anyone who's wanting to sort of type up as they go along, I did put the slides on Moodle 15 minutes ago. So if you did want to use them, they're there, but there's no particular reason to, you can just look at them afterwards. So in this block of seminars, we're looking at, I call them the trademark seminars, but obviously because of the nature of the sorts of things that we're going to be discussing, we're very much also going to be looking at, in particular, geographical indications, which are a very different type of right to trademarks. To some extent, we will also be looking at passing off, which is a very UK-specific tort, which actually of interest to you, given that the class that we're in is probably, it's often described as a sort of UK-type unfair competition tort, but it isn't. But it's perhaps the closest you get in the UK to something like that. So in terms of not breaching our obligations under the Paris Convention, you can sort of point to the tort of unfair competition as one of the ways in which the UK sort of gets over this requirement. So we're going to be looking at a particular rules around trademarks, GIs, and passing off. Now, I'm aware that for some of you, especially those of you who are on the IP LLM, you will have done trademarks before in sort of different levels of detail. I think the main thing to remember for this class is to look at the context in which we're studying these particular rules. So in fact, everyone should be at the same level, and we're doing it sort of in pursuit of the same aims. So this is why I think, especially if you haven't done trademarks before, I would strongly suggest reading the textbook chapter that's listed. So basically the textbook chapter then forms the base level of knowledge we can expect everyone has in the class in order to be able to participate in these seminars. But even frankly, even the textbook material is to some extent sort of more advanced than what we're going to be doing, because our focus here is slightly different. Also, as you'll have noticed, some of the things that we're looking at in particular today relating to collective and certification marks, which aren't exactly a popular topic in the literature. You'll find that we're, in that respect, sort of going beyond the material that's in the text. So, when I mean the context, we're looking at primarily the economic context, broadly conceived. So this is why I refer in the title of the various seminars to the political economy of trademarks, which allows us to broaden it out of perhaps the sort of the standard economic discourses. Is anyone here an economics student doing it as a combined degree, or maybe has an economics degree already? No? Okay, so we don't have to sort of fight to get over sort of that particular hurdle about how we're doing it differently. So you will see here, this is the outline for all of the seminars, and we're looking at particular sort of what I call here thematic areas. And we're looking at the operation of particular rules, such as trademark, GIs, passing off in particular contexts. The first relates to cities and public spaces, And this allows us to look at the way, for instance, trademark law is used by, one of the examples we'll look at is the city of Glasgow to promote Glasgow as a destination or as a sort of cultural hub, etc. The second relates to fashion and fashion cultures, and the third on food and the protection of places of origin. And you can see in that one, that's where GIs are going to be particularly important. So we're going to be looking at the particular rules that relate to these particular themes. But in this seminar, we're going to be largely doing the sort of context and setting up type points. Now, before I start on sort of the substantive part of the seminar, I've had various queries about the formative. I don't think I've ever had so many queries about a formative, which I suppose is kind of nice. I'm going to sort of read it as everyone's been terribly interested in it, but I suspect that the reason most people are asking is that there's almost nothing on this topic when you look at it compared to other ones. So just to explain about the formative, I've said this to some students already. There is material on this. You need to sort of look at adjacent bits of literature and cases, I think, to look at this formative. The idea behind a formative that's on a topic that doesn't allow you to just very easily go to the textbook and just pick out the stuff is that it allows you to exercise both your research skills and it allows you to really focus on the mechanics of actually writing an essay and getting feedback on your structure, your style, your ability to cite material. It also means that probably when you get to writing any of your other summatives, it's likely to feel a little bit more straightforward. So the formative is really about testing your ability to present something that's logically structured, well argued, and to do it in a situation where you've really had to work a little bit harder to go and find materials about it. Are there any questions about this, especially from students who've asked me before, if I've perhaps missed a particular query in relation to it? Anyone? Does this mean we're reasonably happy with it? Obviously, can I just say, we're covering this material in class today, so I think I'm not sort of letting you out completely into sort of the wild of collective and certification marks. And I'm hoping that after the end of this seminar, you'll get a little bit of a sense of how this fits. So for instance, in the question, I can talk about it because it's just formative. The questions asks about the extent to which undertakings can prevent the use of their mark, right? Now, one of the ways that you can answer that question is to consider, well, what is this kind of mark actually doing? And is this actually appropriate to what people might want to do? As we'll see in a particular case that is a rare example where collective marks are used, you may well decide as an undertaking that the better thing for you to do is just to engage with trademark law as normal. So the answer might be, yes, it's useful, but actually this thing over there is more useful, and this is why. And this is something to think about. So think about what the purpose of different kinds of marks is. And that's something that we're going to be looking at this class in particular. So I'm going to give sort of a brief overview of sort of the economic context of trademarks. There's a certain amount of material here. Look at the registration context very briefly. Then look at the different types of trademarks and their validity. But again, in a sense of giving you an outline of the kinds of marks that there are and how they might be protected. So in particular, we're going to be looking at the differences between your sort of standard individual mark and marks that might be used to protect sort of economic rights collectively. So our starting point in relation to trademarks is that trademarks have an economic value. So the first thing that I want to talk about is how we get into the discussion of trademarks as relevant within the market. So again, I want to just emphasize when I say economics, I don't simply mean we're buying and selling things. We need to understand that actually the economic system is supported by a whole host of legal rules. This is sort of political economy 101. The state puts in a particular framework of rules that allows markets to function, right? There are any number of rules, rules of public law, rules of private law relating to, whether it's contract or whether it's advertising or whatever else it is. Trademark law or intellectual property law generally is just sort of one aspect of the way in which markets are structured legally. So remember that this is sort of one part of it, and what we're interested in is the particular economic effects that trademarks, for instance, will have in the market. So if I have this statement, a registered trademark is a sign that has economic value, and the question here is why? Well, another way of rephrasing that question is, what does trademark law, what does a trademark law system do that enables a sign to gain economic value? Now, a sign might be a word, it might be a picture, it might be some aspect of branding, right? Now, this in and of itself may be quite useful, but it doesn't, by itself, it's not going to be transformed into something that it has economic value, or at least not directly. What trademark law does is transform that sign into a property right, effectively. So trademark law looks at your sign and says, am I going to grant you a registered mark? If the answer is yes, because you meet the requirements, you now have a property right. If you have a property right, you have something that you can trade. You have something that you can assign, you have something that you can license. That sign that is sort of intangible and doesn't really seem to be something that you can work with is now turned into a property right. So this is why we talk about trademarks in the context of a market. Primarily the reason we can talk about them is because they are property. This isn't the only thing that's important about them, but it's obviously it's pretty much key. This is where, as a trademark proprietor, you gain your economic power to assign, to license, etc. So this then brings us, in terms of, in particular, the economic literature on this. This brings us to the question of, does trademark law work for traders in a broad sense? Does it work for consumers? And sort of more fundamentally, there's a question about the various sort of economic rationales for protection. And so looking at sort of taking out some of the concepts that come out of the material that's on your reading list, and to some extent that will also come out, although perhaps a little bit less directly also in the cases. The primary one that will arise is the first one, which I said, well, if your mark now has an economic value, this allows you to sort of structure or facilitate competition within the market. Now, I know that you've done lots of competition law. Some of that, of course, will have been on various IP rights. You will have seen exactly how powerful it is to have an intellectual property right, but also how perhaps it gets you into trouble when perhaps you become a little bit too powerful, and then you have to sort of worry about, whether you're exhibiting sort of monopolistic tendencies and the like. But certainly in relation to trademarks, one of the key arguments for trademark regulation is that it allows for the facilitation of competition. So you can structure economic relationships between traders through trademark registration. But that, of course, isn't the only thing that's important here. So it's not only going to be, can you sell or can you assign your trademark to someone else? It very clearly plays an important role in the market in relation to consumers. Now, as you will have seen, and again, this is a sort of very fundamental question of trademark law, you will have seen this in your textbook reading in particular. A trademark serves a very particular economic function in communicating who a trader is, both to other traders and also to consumers. So this is put in sort of in another way as the primary function of a trademark is to serve as a badge of origin. So a trademark serves as a badge of origin in the sense of saying to a consumer, and indeed communicating to other traders, that a particular good or service comes from that trader. So it is made by a particular company or by a particular individual. This is important both because the rules of trademark ensure that you can't have the same sign or the same registered trademark once registered for the same class of goods and services. This means, of course, that a consumer isn't confused about where goods come from, and other traders know not to enter, well, ideally, obviously, we have lots of infringement actions. Other traders should know not to enter a market using the same mark as somebody else. Now, when this works, it means that, let's imagine a very small market for the sale of coffee. So if someone comes in and they want to sell coffee beans, let's imagine you're sort of, I don't know, artisan roast down the road on Gibson Street. You sell your coffee beans and you have the artisan roast logo and the name, that's registered, that's fine. You go into the market. Any of you who go to that cafe, you go in there, you know the coffee that you're going to get. You know where it comes from, it has the logo, you know it comes from artisan roast. If a competitor wants to enter the market, they are not going to be allowed to obviously register the words artisan roast for coffee. Why? Because if you then enter a different coffee shop and it says artisan roast, you're going to assume that it comes from the original artisan roast. It's no longer performing its origin function. So that's bad for the consumers, but also it doesn't help the new trader to differentiate their goods and services. So they might instead say, we're leaving Gibson Street and we go out onto Great Western Road and there's Paper Cup. So now they have a new logo. So now you have two traders who can happily compete, both in the sense that they know what their individual logo and name is, and consumers aren't confused about where the coffee comes from. If yet another trader enters the market, they will again be encouraged, quite literally, by the registration rules of trademarks to choose yet a different name in order to be able to compete. So we could say that trademark law in sort of economic terms allows consumers to reduce their search costs. You reduce your search costs because that trademark is effectively a shortcut. Right? It tells you who the trader is. You don't have to spend a whole lot of time trying to figure out what this mark is. Now, where things get a little bit interesting, although that isn't something that we're discussing today, is to what extent you can prevent other people from using the sign that you have registered, perhaps in adjacent classes of goods and services, especially if you're a very well-known mark. To what extent might you end up having sort of too much power to prevent other traders from using the mark? So sort of in the broad sense of, to what extent might you use your mark to be anti-competitive, sort of broadly conceived. So that's one thing to look out for. The second point to look out for is that you can, of course, also use your trademark in a way, not just as a badge of origin to communicate something to consumers, although obviously this is important, but that you might use it as part of your intellectual property rights portfolio more broadly, to sort of cement your position in the market. And now I'm just trying to think whether I mentioned this example at the very start of the term. I suspect I might have in terms of overlaps. But when we look at something like patents, when your patent expires after 20 years, chances are that what you're then going to look to do is to take advantage of trademark law to maintain your market position. In fact, obviously the sensible thing once you have a patent is to immediately register a trademark for, say, your pharmaceutical or your machine or your process, because you basically have 20 years to educate your customer base or your suppliers or whoever it is about your invention and what mark you are selling it under, that even when your patent expires, you still have actually quite a good economic position in the market, because chances are that consumers will be willing to pay more for your product because it has your logo on it, even though you may be able to buy a generic. I mean, I think the example I would have given is that when you go into a pharmacy, you have, say, branded painkillers and then generic painkillers that are cheaper, but clearly the ones that are branded are being, they're being sold. They haven't disappeared off the shelves. So they are, there is sort of an added value, an added quantifiable economic value from having this registered trademark. I mean, sometimes it gets you into trouble. There was a bit of a controversy about this in Australia, I think it was a couple of years back, in relation to advertising, where they weren't being quite as clear as they should have been about what it was that they were actually selling, or they were selling exactly the same drug under slightly different branding within their larger brand, where I think where it was much more expensive than exactly the same painkiller in slightly different packaging. And at some point, so in relation to trademarks, you can obviously register anything that's valid. In relation to sort of advertising and consumer protection, the relevant body went, actually, you really shouldn't be pretending that this is something different when you look at sort of the chemical composition and you're literally selling exactly the same thing. It was just that they'd identified that it relates to different types of pain, but in fact it's the same painkiller sort of across the board. So just bear in mind that you may have this economic power. It doesn't mean that you can sort of go all out and do anything. So there are, I mean, you will have come across, certainly in the literature, the two particular authors that that are particularly relevant in this context, Alanders and Posner, who look at sort of the economic justifications of intellectual property law. Generally, I think it's particularly important in the context of trademarks. And they look at sort of a market that functions. I mean, I'm being perhaps a little bit unfair about using a sort of broad brush approach to their work, but thinking about, say, roughly speaking, a perfectly competitive market in which we are rational actors and we choose, we have information and we choose things partly based on cost, partly perhaps based on how easily we can identify where a particular product comes from. The main criticism of that kind of model about competition and the role of trademarks is, of course, as you can tell from what I've said so far, is that no market is going to be perfectly competitive. And you will have traders that will have particular advantages, and some of those advantages will come from creating a particularly strong brand and from having a particularly strong trademark. I'm not suggesting that there is anything inherently wrong in this. They will have invested sort of time and money and effort into sort of building this particular mark. But the point that's made is that having done that, the rules related to registered trademarks will allow you to sort of embed, to sort of bed in that particular powerful position. Again, not making sort of any judgments about this, you know, and sort of leaving aside slightly sort of consumer welfare aspects. Trademark law will in fact allow you to effectively differentiate yourself from other traders to such an extent that you can charge consumers more. Again, this is perhaps not that surprising. And this is something that's interesting, I suppose, the final point about this sort of economic model, and then I will come back to, I have a slide that sort of summarizes these points, is that interestingly, when we look at sort of the building up of a brand, let's say a patented pharmaceutical that's no longer patented, is all the money and the effort that's expended into building the brand, while there's a sort of initial outlay. Once it becomes successful, once it's established, and the more products you sell, the more powerful your brand effectively becomes, and the more valuable the trademark that's part of your brand, the more valuable it becomes as well. So when we come back to this question of, you know, where does the economic value come from? Well, it comes from its ability to function as a property right, or it is a property right. It means that the amount that you're able to charge now to license your goods can, if you're economically successful in building your brand, actually increase over time. Obviously depending on a whole host of other market conditions. But in this sort of basic scenario, especially if you're first in, say with a particular pharmaceutical, you actually get a really big advantage. So what's the summary here? The summary in terms of why it might be helpful to have trademark protection is, the first is that it prevents producer harm. So this is for the original trader who's selling something. You're able to differentiate your goods from that of another trader. They can't come in and basically use your mark or sign to sell their own goods when you're the one who's invested all of that money in, say, building your particular mark and brand. So it prevents free riding by competitors. It also prevents confusion, both for competitors and also for consumers. This goes back to the badge and origin function, which I just mentioned. And then we come to sort of these two ideas. This in part, again, from the literature, and especially in the context of this article, which was on your reading list, to two suggestions about the way economic value is built, which are perhaps a little bit more controversial. For instance, you sometimes come across this idea that, you know, in intellectual property acts as an incentive. I mean, I'm not sure that we entirely need trademark law to act as an incentive to create marks or brands. Chances are that in the economic context, if you want to sell people things, you are very well incentivized to create your brand anyway. Because you want people to buy your product, you want to create a particular aura around it, or branding. So that one's perhaps a little bit controversial. And that's related to this idea of, do we need to incentivize brands to create atmospherics? So in relation to luxury brands, for instance, the idea that you're getting a sort of premium experience, or you're part of a sort of exclusive club, is this something that's sort of an appropriate role in terms of trademark law? So one of the criticism that Lemley and McKenna have of trademark law is that there are lots of arguments around free riding. So in the sense that unless you have trademark protection, traders will be able to free ride on the investment that the original trader has made into their brand and into their sign. What they say though is, well, can you really explain why free riding is so bad, effectively? Can you really explain why the particular benefits should accrue to that first trader. In other words, what is the particular injury to that trader? So you need to be able to articulate why it would be bad for a new trader to come in and free ride. In particular, if the new trader is coming in free riding and the product is cheaper, for example, because actually that kind of seems better for consumers. But there's this sort of idea of, but it's just unfair. And what they're saying is, well, we need to be able to articulate exactly why such a position is unfair. And they say, in particular, we need to be able to identify, well, unfairness not only in the context of they are selling something, but in the context of why should we allow trademark law to effectively give control of sort of whole segments of a market to particular traders. Now, I'm not suggesting that this is wrong. They're simply, what they're arguing is, we need to identify precisely what the harm is to the trader if we do not allow them to control a part of the market through trademark law. And they sort of then provide, although sort of different theories about how and when a trademark proprietor should be allowed to control their marks. They look at particular in relation to ancillary markets. And they suggest that it's not perhaps terribly, as they say, terribly persuasive. And so what they conclude, or one of the conclusions they make, is that this perhaps makes much more sense when we look at direct competitors. So putting my own sort of gloss on this, if we look at trademarks, they make sense where, in relation to, say, the coffee example, you have competitors in, say, the same or the similar class of goods. They are literally in the same market. It makes sense that you would have trademark protection to protect the traders from some kind of unfair competition. It makes sense for consumers in the sense of knowing where the goods come from. But what they then say is that this argument for trademarks makes less sense where you're simply seeking to preempt competition in an ancillary market, or before this even becomes an issue. So it's more difficult to make the argument in particular where it's a completely different class of goods. So this is a particular problem when we look at trademarks that are well known or have a reputation, where you're arguing that actually you should have some protection in a market that's not actually even your own market. And at that point, the argument sort of extrapolating from this is that you're allowing a particular segment of a different market to be captured is too strong, but that's kind of the word I'm going for, where it's not actually justifiable to do that. So we're always having this question, this concern about what is the competitor effect, what is the consumer effect. So this is what we talk about when we talk about the market. What is the trademark effect on competitors? What is the trademark effect on consumers? And one way of framing that as a question, and this is something to think about, I think, over these seminars as a whole, is what is the relationship between trademarks, economic value, innovation, and competition? So trademark law as a way of allowing economic value to be generated from particular signs, what is the effect of that on competition within the market, both with competitors and consumers? And whether there are also difficulties here more fundamentally relating to innovation, which should, I hope, be a little bit familiar to you by now because you've done competition law and IP in particular in relation to, I think, patents and innovation. And one thing I would ask you to look for in particular is the way in which trademarks may raise costs. And I don't just mean in relation to they add value and therefore might raise costs for the consumer, but also in the way that they raise costs for a competitor who's seeking, a trader who's seeking to enter the market. Okay, so how do we, this is sort of the economic context and some of the questions that are raised. I now sort of step back to the start about, a sign has an economic value once a trademark is registered. So I want to provide a sort of brief overview of basically how do you register a trademark in order to be able to realize its economic value sort of directly. In broad terms, and we're focusing on the UK here and looking at the EU system now, this is harmonized. So we have the same rules in the UK as regulate trademarks in the EU generally. Much like with patents, although as we know, European patents are not EU, you need to apply for a UK trademark, you need to apply for an EU trademark. Why does this matter in the context of the market? It matters because intellectual property law, as you know, is highly territorial. You need to identify where you want your trademark in order to be able to realize its economic value in the most appropriate market. If you only want to sell your goods and services in the UK, you will apply to the UK Intellectual Property Office. If in fact you think your market is going to be EU-wide, you apply to the EU Intellectual Property Office. So you submit your particular sign, and I'll come back to the validity of signs in the second half of the seminar. You look at it, you submit it for examination, and then the examiner, whether in the UK or in the EU, will check against the various rules for trademark registration. This will then be published. People may oppose it, so other traders, on the basis that this trademark already exists, for instance. It will then be registered, and you can go off and use it, you can assign it, you can license it, etc. And just sort of leaving aside the possibility that someone might then seek to actually revoke it. So the key thing is that you gain your property right either in a UK trademark, or your property right is the EU trademark, which you can then use within the EU, within the UK, but also you can sue others for infringement. So you have something that you can directly use. Question? Yes?
I wanted to ask if this is like this now because of Brexit. Otherwise, UK is not a part of the EU.
Oh, right, yes. So, no, you can designate individual member states quite apart from Brexit. So I am going to mention Brexit in a moment. But no, so any trader within any of the member states of the EU could say, I'm just going to have a trademark in Germany, or I'm just going to have a trademark in Italy. Or in fact, I'll have both. I'll just cover all the bases, and I'll have one in Italy and then one in all of the EU. Now, the Brexit question I'm going to come back to, because yes, it does in fact pose potentially headaches for traders. And actually, so the one thing I will say is that obviously if you have an EU trademark, it might be a good idea to also, well actually I'm not even entirely sure what you would do. You'd probably, in terms of the UK, you'd probably want to make sure that you also have a UK one. You should need to do this, but it might not be a bad idea. You may also decide that actually you sell goods and services that will be of interest to a variety of markets. So you may also want to sell your product in Australia and New Zealand, for instance, or Thailand and Malaysia, or also Canada, whatever it is. You could also use the international filing system under the Madrid Protocol. Now, what this allows you to do is, at an international level, designate particular markets, so particular countries where you want your trademark to be valid. This is sort of simple, it's cost effective, because you don't have to go through each individual state, but each individual office is still going to have to examine your trademark in relation to its own particular set of rules. So even if you designate the UK or you designate the EU as your relevant territory, you can't use this system in some way to get a trademark in one go. You don't get an international trademark. You use an international process in order to register that trademark in different places. So this brings us to this question of harmonization and Brexit. Now, of course, UK law is harmonized with the EU. It means that the EU cases, whether they're sort of preliminary references from the UK or from other member states, are obviously going to be very important in terms of identifying what the specific rules are. And the most recent change to trademark law, the most recent EU changes following the EU trademark regulations. Now, the EU trademark regulations regulate EU trademarks, but those same rules are transposed into the Trademarks Act 1994. And the last lot of changes to this were incorporated, not incorporated, as in sort of transported, on the 14th of January of this year. Incidentally, that might mean that your statute books are out of date, as I was discussing, I think, was it with you yesterday? Yeah, so there are particular small changes that, in relation to wording, that may well not be in there. Okay, so to this question from the back about Brexit and what happens. Now, without at all getting into and thankfully I'm not a UK public lawyer, which as you can imagine is quite a fun job to have at the moment. I mean, literally everything changes. I can see with my colleagues, like sort of hours before a lecture, something new has happened. And we don't have to worry about this so much. The point that I want to highlight is the European Union Withdrawal Act 2018, not to be confused with all the acts that weren't recently passed in relation to the actual exit. This provides that EU law does not apply after Brexit, but all EU law is being transposed into UK law. So we just let that sink in for a moment. You exit the EU, but before doing that, you immediately put all the laws onto the books in the UK, which sort of makes sense, right, for continuity. It's just, if I'm honest, it sort of seems, it's perhaps a little bit funny. This means, of course, that this will include trademark law. So it's not as if, come the Brexit date, assuming that that is now January, that EU law will suddenly stop applying. That's not entirely the case, because given that it's highly harmonized, as at the exit date, there are going to be the same rules. Now, there may be convergence or divergence after that. There is this difficulty about exactly what will happen to all of the EU marks as a sort of technical issue. The suggestion seems to be is that they will be valid. They will sort of just be incorporated into the register. It's not quite clear exactly what that would look like. It is also not exactly clear to me what, say, the trademark law might look like 3 or 5 or 10 years from now. For the EU students amongst you who have sort of any passing familiarity with the negotiation of EU third country trade deals, this takes a while, and this includes not only sort of questions about how will we regulate trade, to what extent will it be free, but it also incorporates negotiations around regulations. So to what extent, for instance, countries will seek to converge on particular rules. Again, this will be something for those of you who end up practicing. By the way, for those of you who are also from non-EU member states, this will be something that will continue to be relevant. So So I suppose in short, to the question about Brexit, the position is perhaps a little uncertain for traders at the moment. However, if you're interested in looking up sort of what this looks like on the practical side of things, on the gov.uk website, there are various sort of notes and explainers for businesses, you know, as sort of prepare for Brexit. This is what you can expect. And there are also various sort of explainers relating to intellectual property law and what might happen. So if you're interested in looking at that, I think, you know, see what it says, but again, bearing in mind that it's entirely possible that this will change. Now, to round off this particular section, before moving on to validity, I want to talk about this phenomenon of submarine trademarks, just because I found it quite interesting. And this is in the WIPO report that's on your reading list, or it should, I think, be on your reading list, this is particularly now looking at US trademark law and its interaction with the international filing system. Now here, I'm not interested in the validity rules, but just explaining that in terms of the way you might seek a market advantage, it won't only be by ensuring that you have a validly registered sign. It's that you may be able to use the procedural rules here in relation to international filing to your advantage. So what do I mean about this? A submarine trademark effectively is a trademark whose publication is delayed in some way. So obviously, once you apply for a trademark, you're disclosing to everyone that you now have this new sign. Okay, so you're disclosing it. One way of ensuring that people don't know about it is by using the international filing procedure in conjunction with, as you will have seen if you looked at the reading, basically shell companies. So you try to conceal yourself as the owner of the mark. So you use the Madrid system. You perhaps you use a separate company that's not your own company name. And in that way, you get a little bit of time before your actual sign pops up on, say, in the US journal. If you're interested, you can search, you can look at, the UK IPO, you get this weekly, by the way. You can look at the Trademarks Journal weekly. And I'm particularly aware of this because I've looked at the last 6 weeks of journal looking for examples for you of collected marks, and I found one, just as an aside. But these are all published, so you can see this is the sign, this is the person who's applied for it, these are all the classes that they've applied for, and it basically allows competitors to raise objections. Now, where this idea of a submarine mark comes from is that they allow it to be hidden for a little while before it sort of appears, because they use the international procedure, before it appears on the relevant in the relevant country register. And the example that's given in this particular article is by Apple, and this related to the filing for the Apple Watch logo back in, this must have been about sort of 2014. Now, Apple initially filed where? Not in the US, which you would imagine is a massive market, but in Trinidad and Tobago. So they use a sort of roundabout way of not sort of alerting potential competitors to the existence of this particular sign, which of course, you can see why they might want to do that, because that actually gives away what they were seeking to produce. And it allows you to sort of, the idea is that it allows you to control the narrative a little bit about when you reveal sort of your product to the market. And what you're able to do then is, there's nothing sort of inherently sort of shonky about doing this, but it allows you to use that as the priority date for your trademark filing. So you get in first and quickly, but without it being immediately obvious to everyone that you have actually sought to register this. So again, without getting into whether this is sort of negative externality of some kind for competitors and consumers generally, we can see that trademark rules are important not only in relation to validity, but also the way you use the process of trademark registration in order to perhaps attempt to get some kind of market advantage. Okay, so I think that we should have a 5-minute break, and then we're going to come back to the question. Different types of trademarks, and sort of the basic rules of validity. So when I was saying, well, you have a sign, you validly register it, and this is sort of as if by magic transformed into a property right. How do you do that? And well, we start with noting that there are different types of trademarks. The first, and this is the common one, this is the vast majority of signs that are registered as trademarks are individual marks. And by individual, I mean by an individual trader. So person or company who are selling particular goods or services. So these are sort of the standard ones. In addition to that, there is the possibility of registering either a collective mark or a certification mark. Now, these have slightly different rules to individual trademarks. Many of the same points will still apply, but the distinctiveness test is going to be slightly different because they relate to collectives, to groups, and a variety of different traders, whereas individual marks relate to, they link a mark to a specific trader. Both collective and certification marks can link any number of individuals or traders to that particular sign. So the requirements are slightly different, including the need to sort of file regulations for their use, which obviously you don't need to do for an individual mark. So in relation, of course, to all of them, the validity requirements are linked very much to this idea of what information are you communicating to other traders and to consumers. In relation to individual marks, the distinctiveness requirement is very strong and important because you're saying this is a badge of origin, this mark is linked to this particular trader. For collective and certification marks, to emphasize the distinctiveness requirement is a little bit weaker because it's effectively a group mark. So it's not saying it comes from this particular trader. It's saying, especially in relation to certification marks, this particular good is of a particular quality. It's not that it comes from one trader, it could come from a number of traders, but it has a particular quality. For instance, it's certified 100% cotton on clothing. Obviously, lots of people can make cotton clothing, but only certain people might be able to use the relevant cotton mark to demonstrate that. Again, in relation to all of these, this should be the idea behind the validity criteria are that traders and consumers should be able to rely on this information. So the question, the underlying question in relation to all of these kinds of marks is, what are the particular market effects, both on traders and consumers, of individual, collective, and certification marks? So to what extent can consumers and other traders rely on these marks, either to gain some kind of economic value or to gather sort of relevant and correct information? And this is something that's highlighted at the very beginning of the Trademarks Act. So this is Section 1. This will be familiar to some of you already. A trademark in the very first Section 1, subsection 1, a trademark is a sign oh no, that shouldn't say graphically, that should say representable, which is capable of distinguishing goods or services of one undertaking from another. I will update these slides for Moodle. And in particular, it's going to consist of words, personal names, designs, letters, etc. But what's in particular of interest to us is that references to a trademark include also references to a collective mark and to a certification mark. So I'm going to start with collective and certification marks before looking at your more sort of standard criteria for individual marks. Now, a collective mark is a mark that distinguishes the goods or services of members of an association from those of other undertakings. So immediately the difference between an individual and a collective mark is that it relates to an association, not to one particular trader. Now, as I was saying, I was trying to find sort of very exciting sort of collective marks, and after wading through sort of 6 weeks of the journal, I went back to a sort of trusted, obvious one, which is obviously not very exciting. I'd only found like one other one, sort of that's very recent. And this is the collective UK mark for chartered accountants. So it's an obvious one, right? Because if you think about the kinds of organizations that might want to make use of a collective mark, professional bodies like accountants or surveyors or architects, etc., this is something that's quite useful. And in this case, you have the sign. The sign is CA, obviously standing for Chartered Accountants. It's sought in the relevant class. Remember, you always have to have identify both a sign and a class in which you want it. In this case, it's class 45 for things including legal services. And the trademark proprietor is the Institute of Chartered Accountants of Scotland. So in this particular case, there are a few different CA collective marks. But in this case, you have the Institute of Chartered Accountants of Scotland. So this is an example. So what are your sort of particular, just leaving aside particular questions around distinctiveness of particular signs, what is it that you must demonstrate? As you can tell from that example, you need to demonstrate that you actually have an association, right, of whether it's the producers of services, like our chartered accountants here, but it might be anyone else. It might be to do with food, it might be to do with the production of clothing or whatever else, but you need to have an association. And that association needs to have legal personality. Why does it need to have legal personality? Well, you're getting a property right, so you need to be able to actually do something with it in the market, otherwise why do you have it? So something that the UK Trademarks Examiner is going to look for is that you actually have an association that can validly apply for this mark and that has legal personality so it can actually use it. There is no point in registering a trademark that somebody can't use. That sort of rather defeats the purpose. There will also be, and this is something that's special about collective marks, you will need to identify appropriate regulations. So in other words, these are specific rules that relate to your specific mark. So in relation to, say, the Chartered Accountants, these will be rules about how you can use that collective mark. So this will include information such as who is authorized to use the mark. Now, I'm guessing if you're a chartered accountant, you will need to have passed particular tests. You will probably, or actually let's use lawyers maybe as an easier example. So when I became a solicitor of the Supreme Court of New South Wales, I needed to have done the professional qualification. I needed to have worked as a solicitor for a particular amount of time. I needed to do continuing professional education modules to demonstrate that I'm, that I was fit to remain on the roll of solicitors. So my solicitor's firm would then have had, may have been able to use a particular collective mark. So this is what I mean about regulation, sort of setting out who is authorized to use the mark, and that is linked to these sort of conditions of who is able to become part of this association, so they can say, I am sort of regulated, I am a sort of a member of this particular body. The regulations will also include questions around, well, how are you allowed to use the mark, and what happens if you misuse it? Are there going to be some kind of sanctions? This makes sense, especially for professional bodies, because you don't want to allow people to say use a mark suggesting that they're in some sense a registered solicitor, and then it turns out they don't even have a law degree, and they don't actually even know how the court system works, or whatever it is. I mean, just as a sort of basic element of consumer protection, that would be a very bad idea. So how does this look actually in the Trademarks Act? So we are now looking at section 49, and in section 49, subsection 1, capital A, the way this question of do you have legal personality, the way it's phrased here is that you need to have a capacity to enter into contract, to sue or be sued. So you need to have this particular legal personality that allows you to use the mark. So you're a member of a club. That's what we're talking about in association. You're a member of a club of producers, not just for goods, but also for services. Now, a little bit more information, perhaps not giving too much additional detail, is found in Schedule 1 of the Trademarks Act. So paragraphs 2 and 6 related to collective and certification marks offer a little bit more information. And here on the distinctiveness point, Schedule 1, paragraph 2 says, well, when we look at a collective mark, we're looking at distinguishing goods and services of one undertaking from those of other undertakings, but in relation to collective marks, an undertaking means the association. So you have a whole group of people who, if they meet the regulations for the use of that particular mark, all get the protection of this particular mark in the sense that they can all use it to distinguish themselves from, say, unauthorized undertakings, so those who are not part of the club. However, there are certain limitations to this, and we can see this in paragraph 4. And this is that the UK examiner is not going to register your collective mark if it's going to be misleading. So you may meet otherwise your requirements, you have rules, but they're not going to allow the public to be misled. Yes?
If you're part of that collective mark, would you add something to the name of it, for example?
I suspect that that would be in the rules. So chances...
individual, actually.
Yeah, so I suspect that there will be rules that will be included with things like there are certain situations or contexts in which it can't be used. So, and if it came to that, you wouldn't be allowed to because, for instance, it might be misleading, or it might lead consumers to think that you're doing something other than what this is, or you're trying to use sort of the good name of the association to promote something that is in fact against its rules.
For example, we have a grocery shop in Germany, it's called Rewe, it's actually a really huge company, and in some parts in Frankfurt we have, like, for example, Rewe Shahin, which is obviously not from the company itself, and also it's like a Turkish name, and I think the owner is Turkish as well, so they sell Turkish pastry inside. And like, would that be a collective mark?
That actually just sounds like an individual mark to me.
He took the name of it, big grocery shop, so is it not a collective?
Oh yeah, but then the big grocery shop can just sue them for infringement of their individual mark, rather than, it's not, so it's not...
So this wouldn't be a collective mark?
No, but, and something that I'm going to come to at the end, is that sometimes it's a little bit difficult to see in operation the difference between a collective mark, and this is perhaps why we don't see as many of them, and the non-exclusive licensing of an individual mark to multiple traders. So hold that thought, because I think it becomes sort of, I think, quite important at the end. So why might you use it? You might use it often to designate something about the quality of the goods. And Schedule 1 paragraph 3 in particular identifies that what you might want to do is to register signs that designate the geographical origin of goods or services. Now ordinarily you're not, as a general rule, especially in relation to individual marks, you want your mark to be distinctive and it has to be more than descriptive. But in this case, it's saying actually no, you can, assuming that nobody's being misled, you can designate geographical origin of goods and services. So perhaps to use the example from the back, not in relation to the supermarket, but you're the producer of sort of amazing, delicious Turkish pastries, and it turns out that there's an association for, I'm just trying to think of a Turkish pastry. Is baklava a Turkish pastry?
Yes.
Okay, maybe there's an association of baklava producers. They have a collective mark. They can say, these are the specific, they're describing the origin of the pastries, and they can allow then people who meet their requirements and standards for the production of these to use their collective mark. That might be an example. Now, of course, you might be thinking, why didn't they just apply for a GI? Well, it might turn out that that's a better idea anyway, but we'll come back to that in the final seminar. So, again, notwithstanding that they're allowed to use names that designate geographical origin, there is a sort of break on that in Schedule 1, which says that you can't prohibit other people from using that term. So effectively this functions like a defense for other traders, where they're using those marks in accordance with honest practices in industrial or commercial matters. So just because you have a collective mark, let's use our baklava example again, you don't get to go and sue the bakery down the road for selling baklava pastries. Because chances are they're using this particular word in accordance with honest practices in industrial commercial matters. The honest practice here, I would be guessing, is you need to describe what it is that you're selling to your consumers. So long as they're not perhaps using the logo of that association, right? They won't be saying, I'm part of this. I don't actually know whether this association exists. I'd be sort of delighted if it did. It would be a sort of an interesting example in relation to food. But you're not stopping other people from using that word. So effectively you have a defense, if you're another trader. Why does this matter in our context? It matters because obviously this helps to regulate the market for particular goods where there's going to be a collective trademark issue. Okay, so relatedly, we have certification marks, and as you will see, this is a fairly similar idea. But I will just, so in the sense that it's collective. However, unlike a collective mark, you can use a certification mark without being a member of the association. So to apply for a certification mark, the proprietor needs to have legal personality, but they can enable a whole lot of people to use the certification mark without those people being part of a club. So in other words, you certify other people as, allowing them to use your mark. So I would guess that the fair trade symbol is probably a certification mark. Maybe also something like the Soil Association. This would be my guess, but that would be an example. So you certify these marks in use. So again, as with the collective mark, you would need to be able to demonstrate who it is that will be allowed to use your mark, what are the specific characteristics of the mark. What are going to be the qualities of, say, the food or the clothing items? How are you actually going to ensure sort of quality control of the use of your mark? Do people need to pay for the use of your certification mark? Very often they will. And by the way, there's nothing here to suggest in relation to sort of collective and certification marks that this somehow has to be for non-commercial purposes. You can quite happily register a certification mark that you expect people to pay for. In fact, it's perfect. It's not sort of unusual at all that you should pay, that you would have to pay to be to use a certification mark. It's just the person who, or the proprietor of the certification mark needs to make clear, or to have what the Trademarks Manual refers to as a clear and objective statement that would allow anyone reading that statement to understand what the characteristic certified is. So for example, I grow oranges, or non-exclusively where you privately have contractual negotiations as to who you would authorize, whereas the collective mark embeds that in the mark itself, where at the time that you apply for the mark, you already have the rules about who's in the club.
Would you have an example for a collective one?
So the Law Society of, okay, let me just guess that the Law Society of New South Wales could perhaps apply for a collective mark. Maybe it wouldn't. There might be public policy reasons for why that wouldn't be the case. And I am a member of a firm of solicitors. We could put their logo on it as being part of the association. And they regulate us as to the rules we have to follow to continue using their mark. So that's great. I'm regulated by them, and I'm very happy because I look like I'm someone who's decent and isn't going to run away with my client's money. But then, to go to your example, I might decide that actually I'm now getting a lot of property work and it's too much for my firm to handle, so I enter into an agreement with the firm down the road and say, actually, I want to contract out some of this, but let's enter into some kind of licensing agreement where you get to use my firm's name on these particular matters. That's individual.
For example, could be the L'Oreal Luxe collective mark, because they have like Yves Saint Laurent, Chanel, whatever. Sorry, not Chanel, Yves Saint Laurent, Armani.
No, so conglomerates are sort of, do you mean like when you have like LVMH owns a whole bunch of things, or L'Oreal
Yeah, for example,
owns a whole bunch of
Inditex
brands?
has like Zara.
Yes, exactly. But that's a mode of economic organization.
It's not
of those companies where they have a portfolio of marks, and a portfolio of individual marks won't be the same as a collective. Even if in practice, it might be that the parent company has particular rules about how they want their particular brands to function. So some of them might be, we don't want people to know that we're the parent company, right? Because people then might not buy it, or we definitely want them to know that they're the parent company, so they do buy these individual ones. Excellent, good question. So you can kind of see how, with all of these, you have sort of overlaps, and I think sort of putting the consumer at the center is one way of sort of trying to understand how these different relationships work. Anyone else? I think we have time for one more. Anyone else have a sort of different center to their little table or list or their map? Anyone? Did anyone find a good reason for having a collective mark or a certification one? Yes.
I think certification mark is important in that way, that also the economic function, that it gives the customers kind of safety. For example, there are the certification marks like Halal and Hashkar.
Yep.
There are like certification marks, for example, for people who are religious. They might go for this because they know it's like, I'm safe with eating this, I'm safe with buying this. So their economic functions, obviously, that the customer feels safe and like, I don't know how to say, but
yeah, so actually, and this in fact raises a much bigger issue, which is, sure, it might be about giving you information about what you're buying, but actually in terms of, say, consumer safety or feeling that, you know, their needs are being respected, this is certainly something that a certification mark does, potentially, that actually goes beyond just this sort of economic exchange of, I see your mark, I'm going to buy your product. It has this sort of greater impact. And I think that that's what we actually see across sort of the collective use of marks. That's something that's quite important in the way it actually operates within the market. Okay, excellent. That brings us exactly to 5.2. I will see you next Friday. If you have any questions about this, obviously just send me a